want to go on record of being in favor of those rights that have been extended to Americans and that are potentially in jeopardy. I yield back the balance of my time.
The gentleman from New York reserves. The gentleman from Ohio is recognized.
Thank you, Mr. Speaker. I'd yield 5 minutes to the gentleman and my friend from Texas, member of the Judiciary Committee, Mr. Roy.
The gentleman is recognized.
Thank the Speaker. I thank the gentleman from Ohio. My colleagues on the other side of the aisle paint with a broad brushstroke the language offered by Justice Clarence Thomas, a justice that I consider to be a friend and a great defender of the Constitution and a great member of the United States Supreme Court, despite being pilloried by the left and laid out as something other than the great patriot that he is. In his concurrence, Justice Thomas wrote, after overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are, quote, privileges or immunities of citizens of the United States, end quote, protected by the 14th Amendment. Now, we could have a robust debate in the Judiciary Committee about this whole issue. We didn't do that. This bill was dropped on the body yesterday afternoon, an hour and a half before rules. I went and testified before rules, but we had no benefit of the debate in Judiciary Committee to have a deep discussion about this issue, about the constitutional implications, nor did we have the ability to debate the reality that the words that this codifies Obergefell or codifies Loving are simply false. It does no such thing. It does, as I do think in this case, the chairman pointed out, is that it's a full faith and credit recognition issue, but a lot of the rhetoric coming from the left is that this somehow codifies those two opinions. It does not. It does not do that, because those opinions recognize rights under various legal theories, one of which is substantive due process, which Justice Thomas is pointing out he has concerns with. Because Justice Thomas has concerns with how we make law, how we recognize law. He has concerns about that. The how. It matters. It matters. And that's what Justice Thomas laid out. He never said anything about his conclusion on those specific questions, but rather the how. As my colleague from Ohio, my colleague from Louisiana, both adequately laid out, the majority opinion lays out very specifically their view about the implication of the Dobbs opinion on these other recognized rights under the previous precedents of the court. But I think it merits noting that we're talking about the substance of the issue, that it does matter when the court steps in and makes law. Because we end up where we are right here. We end up in the situation where difficult decisions, for example, when does life begin? When does it begin? And when do we have a duty to protect that life? We could have a very robust debate here in this body if we ever actually debated on the floor of the People's House, but we don't. When does life begin? It's a complicated question. My colleagues on the other side of the aisle don't really want to have that discussion, right? Does life begin at birth? Does life begin before birth? You say, well, it's up to the mother. Well, it's not up to the mother. A week after birth, we, society, protect that life, right? So the debate is, do you protect that life a week before birth? Do you protect that life at conception? These are actually difficult, complex questions involving faith, involving values, involving life. But no, we can't have a debate about that here and have a reasoned debate, because the court plucked that out from the people, and the court manufactured an opinion to define when life begins and how we should deal with it. Now we're talking about other issues, talking about marriage. We've had opinions that deal with marriage. Now my colleagues on the other side of the aisle want to put forward a bill that is clearly political in nature, because they don't want to talk about inflation, they don't want to talk about wide open borders, they don't want to talk about rampant crime, They don't want to talk about the state of this country in decline, heading into a recession, where people are hurting across the country. They don't want to talk about that. So they bring forward a political bill. And then they want to take different issues and policy choices. Marriage based on race, marriage based on sex, that this body didn't define, that state legislatures did define in varying disagreeable terms across the nation. And then the court in 2015.
I yield the gentleman additional 2 minutes.
I think
Gentleman's
Gentleman from Ohio.
recognized.
The court steps in 2015, and now we're 7 years in to recognition of same-sex marriage. Now, we could have a debate about the policy of that decision, but the court steps in and says, there you go. And my colleagues on the other side of the aisle want to purposely, for political reasons, conflate lots of different issues. And I think it's important that my colleagues on this side of the aisle understand what we're doing here today. That we're going to vote on the recognition of marriage as a body, as representatives of the people, okay? Separate from whatever decision a court may make, we're going to make a decision here about the recognition of marriages across state lines where there are differences of opinion still to this day about how one defines marriage. In the name of full faith and credit, you will go to the people of Texas by our elected representatives. To my Republicans on this side of the aisle, Republicans will be voting on this floor today on the question of whether the federal government should tell Texas what marriages they have to recognize, irrespective of what the court has said. That is a vote. That is a choice. That is a decision. And we should not hide behind the use of the Equal Protection Clause with respect to marriage not being impacted
Could we have all
because of
members
race
who are joining us on
to
the
then
virtual
say that
platform,
marriage
please
must be
show your
recognized
face
for
on
same-sex
camera.
purposes
You
by a
need to
vote
have your
by the
face on
body, by the
camera in
people.
order to establish
It's a
quorum.
choice. And
So
we
the
should
committee
understand
rules
that
are that,
today.
not
And we
only
should
do the
understand what
cameras
we're
have to be
voting
turned
on
on,
since we
you
never
have to
had the
be
luxury or the benefit
in view.
or the responsibility of debating
out
this
of
in the Judiciary
sight,
Committee where we should have debated it. I yield
They
back to
don't
the gentleman
count
from
for
Ohio.